Hi, everybody. Thank you for joining us. My name is Christy Stewart. I'm the Physician Relations Coordinator for the Medical Society of Delaware. I want to welcome you all in joining us. I ask that you please, if you haven't already done so, mute your microphones. If you have a question throughout the presentation, you can insert them in the chat box and we'll go ahead and read those during the end of the presentation. I would like to introduce Linda Pappajohn. She's HR consultant for Santora CPA. Welcome, Linda.
Thank you very much. Good morning, everyone. Happy spring. It looks like it's finally here. Um, it's been an interesting year in HR, I think. There were a number of things that probably caused some angst and some wringing of hands during the year. And, I'd love to think that that's over, but I think the next year or so, we're going to see a lot more stuff um, change or come out that in um, in rapid succession, faster than we have seen since before COVID. Today, I'm going to talk about uh, the topics I'm going to cover, and there were an awful lot to choose from. I'm going to look at remote, hybrid, in office, bringing people back. We're going to talk about marijuana update in Delaware. We will do the uh, cover the Delaware paid family medical leave. We'll look at artificial intelligence, and which is kind of like Google on steroids. We will cover pregnant workers protections, what acts cover them and what you have to do. We'll look at the salary thresholds for the FLSA that were supposed to go into effect. We will talk about some political discussions in the office, and I'll wrap it up with updates to the Affordable Care Act's filing, and just to make sure you got the right I-9 forms and the right FMLA forms if you are have to comply with FMLA. So lots of stuff going on. So let's start off with the remote or hybrid or an in-office situation. Everybody got a taste during COVID of that. Yep, you know what? You can work from home, and it can work. So now companies are looking at it and saying, you know what? Let's bring them all back. This doesn't seem to be working as well as it did before COVID. Let's bring them back in the office. But the question comes up now is, can you demand everybody come back? They got used to being at home. And for medical practices, I think the good news is a lot of your workforce couldn't work from home. They had to be in the office. So you have fewer people to bring back, but it's going to be challenging. If you're going to bring them back, my recommendation is you announce it well in advance so people can have time to make necessary adjustments in terms of, getting into work and different other things they have going on. Um, always explain why you're going to bring them back to work. It's not a whim. You've thought about it, but truly, with people working from home and some in the office, teamwork has suffered. That collegiality you had, everybody was a group, good or bad some days. But there was a synergy that connected people, and that disappeared when you had a lot of people remote. Also, your culture. It's hard to um, enhance your culture or promote it when people are in very different locations and don't come into the office. Productivity really did suffer. People say it didn't, and somebody's individual productivity may not have, but the productivity in a group, when somebody says something just in passing, but it's a piece of information somebody else needed, that if you were at home, you wouldn't have picked up the phone, you probably wouldn't shot off an email. So it really can make for better communications if everybody's together. You want to gauge people's concerns about coming back. So before you all of a sudden say, okay, Monday, everybody's going to be back in the office, that is not the right way or good way to go about doing it. But you might have some small discussion groups. Maybe you do a survey to get how concerned people are about it and what are their concerns, and how can you address them. And maybe ask them for suggestions in terms of how could this work. I know for one of the people, a couple of people on this call, you moved your office from Wilmington down to Middletown. So when you had people who joined the company during the COVID piece or before it, all of a sudden the office is in another place with a considerable driving distance. So those kinds of things can happen, or maybe you open new branches and you're going to put somebody else and not going to come back to the place they were before COVID, but they're going to be at a new location. So take those things into consideration. I really recommend you start with a hybrid model. Don't just say, okay, Monday, everybody, all 5 days, you're all going to be back. If you can not do that and you can slow that down a bit and do it on a gradual basis, that can work better. But definitely pick at least 2 mandatory days in the office. And they have to be the same days for everybody, because if it's still split and everybody's not in the office together, you're defeating the purpose of why you said you were doing this. So what I see a lot of companies do is it's like Tuesdays and Wednesdays everybody has to be in, or Wednesdays and Thursdays. And I'm not sure why, but it seems like if they're consecutive days, it works better than, okay, Tuesday and Thursdays everybody's in. But you're going to have to judge that based on your workplace. You want to set some clear expectations that no, this isn't just 2 days you get to come back and 3 days you work from home. This is the process, and eventually we are moving to increasing those in the office days. So don't give them a false sense of hope. You want to, if you have to, stagger some arrival and departure times, just to help people get adjusted to this, and particularly in terms of somebody's commute or possibly childcare concerns. A number of people took remote jobs because they didn't have this long commute anymore, and now they're going to be faced with it. Certainly, with daycare issues or school start times, uh, those could play a big factor in somebody's being successfully able to come back in on a regular basis. But there's no law that protects these people that are home remote now that says this is how it's going to be forevermore, unless you had some arrangement when you hired them that said this will always be a remote position. And hopefully you didn't do that. The one thing you have to look at, though, is do you have any employees who have used the remote work as a Americans with Disabilities Act reasonable accommodation? They have some situation going on medically, health wise, that would qualify them for an ADA accommodation that would be remote work. I know we have somebody like that, a couple people like that. And so even though we bring people back, they're hands off. We don't. Now, just because they've got the accommodation now doesn't mean that it could be forevermore. Somebody could have a situation and uh, a few years ago and it's changed, but they haven't said anything in terms of they don't need that accommodation anymore. So look at those, handle those very cautiously, but do make sure that you're taking those into consideration. All right, the next really fun one is Delaware and the marijuana update of what's going on with it. Certainly we have recreational and medical marijuana. Back in 2015, 10 years ago now, that went fast. Medical marijuana was legalized in the state, and the state set up approved dispensaries across in the counties. In order to purchase marijuana, though, somebody has to have a Delaware medical marijuana card. And it's interesting because back last summer, I did an HR roundtable in the office with a labor attorney, and he said to the group, and this is construction people, has anyone ever seen one of these medical marijuana cards? And I think there's like 16, 17 people, and we're all like, no. And it's like, do they even exist? And everybody was like, we don't know. We've never heard about them. I did Google recently, and yes, there is an official marijuana card. And to get one, you can apply online or you can do it by mail. But there's an online form that somebody would get. They would have to have a certificate from a healthcare practitioner in order to apply for that card. And there's 4 different medical people that can provide those certificates. I'm going to guess maybe some of your offices are included, do this. Medical doctors, a doctor of osteopathic medicine, the advanced practice registered nurse, or a physician's assistant can sign a certificate in order to get the card. Now, when you have the marijuana card, it allows you to purchase up to 6 ounces a month. And I think it's a maximum of 3 ounces every 14 days. Those cards are good depending on the situation for a year, and then they would have to be renewed with new certification, or some of them, based on the medical situation, could be good for up to 3 years. Um, but just because somebody has the card doesn't mean you have to allow them to come in the office and be under the influence of cannabis. Right? It's not a get out of jail free card that I can do what I want and I can go out at lunch and have a few tokes out in my car, or I can sit here in the workplace and have some gummies, or all of the other different forms cannabis comes in now or is available. So you can prohibit people from being under the influence when they are at work, even though they have a card. You want to address this in your substance abuse policy or your drug and alcohol policy, whichever you call it. And you want to be very specific that this includes marijuana. Uh, you may have somebody who has an ADA reasonable accommodation. Maybe they're going through chemotherapy and for nausea. They have the card, but it still doesn't mean they can do it at work. Uh, but once again, check those people who have the ADA accommodation, and have a discussion with them, or think about how this would work in terms of when they're using and their work. All right. Then along came recreational marijuana, and that was effective back in April of 2023. And we say, well, gosh, that was almost 2 years ago. Where is it? Well, it's not here yet. Delaware has been holding it up in terms of zoning laws. There's a lot of protests going on, and people are saying, yeah, recreational marijuana is great, but not in my area, not in my town, not on our main street, not next to a school, not next to certain businesses. And that has really kind of put the brakes on the having it available to the public. There's also an issue going on with fingerprinting authorization. So at the moment, it's not available. Not that people can't figure out where it's available, all right, and then go over a state line and get it, but it's not here in Delaware yet. Once again, it's still federally prohibited. My favorite is, I don't know if anybody ever goes up to Maine, but I was in Maine over the holidays in this past summer. And in all the little towns, there's all of these, I'm shocked, on the little storefronts, there's two or three stores selling marijuana. The billboards on some of the state roads are just amazing how many companies there are selling recreational marijuana with some very clever names. I think one was Sweet Dirt, and that was Cannabis Haven. And I'm sure I'm going to be really regretting Googling that one in the future, because who knows what I'm going to get now for um, junk email. Anyway, but they didn't seem to have a problem with legalizing it up in Maine, and it seems like everybody could just open it. There doesn't seem to be a whole lot of laws prohibiting it. Keep in mind that it is still federally prohibited. Feds have not allowed it. It's not a legal substance. And whether or not the feds do it or not, you can prohibit it in your practice in any form. And you would want to include in your policy that all forms of cannabis, medical and recreational, prohibited in the workplace. You can't be under the influence. You can't be selling it. You can't be distributing it. All of the normal stuff of an illegal drug. But you really need to specifically state marijuana or cannabis other than just illegal substances, because illegal substance, well, it's legal in Delaware. In your policy, I really, really strongly suggest you look at your drug and alcohol policy or substance abuse one and see what it says. And now's a great time to update it before recreational becomes readily available. There is, at the handouts that Christy is going to send you for this, for my slides, There's also going to be a sample drug and alcohol policy, and there's another policy that I'm including it, but it's a sample one that gives you all the pieces. So you can see, you can either adopt that one or customize it or put some of the pieces in your existing policy. But you want to include it's prohibited in the workplace. You also want to include, if you don't have it, testing for reasonable suspicion clause. And this isn't just for marijuana. This is for any illegal substance or alcohol. If you suspect somebody is under the influence of something based on behaviors you've observed, you want to have the right to send them out to be tested. Now, marijuana, it's a little tricky because it can stay in your bloodstream for about a week. Uh, so maybe they're not under the influence right now when you send them for testing, but it would come back as a positive test. The reasonable suspicion clause, I like that one best for drug testing, unless you have a very strong you drug test at when you hire somebody, you do a drug test. A lot of companies have the standard random. We may do random drug testing, and the one I hear so much is, well, we suspect Michelle's on drugs, so we're going to do random testing. We'll just make sure she's in the test group. That's not a great idea because it's really not what random means. Plus, you've now ticked off a bunch of other employees that you're going to have to send as part of that random test who, there could be not a prayer in heck that they would ever do drugs. So I really recommend you do it for the testing for reasonable suspicion. That gives you the option if you want to do it. In a lot of cases, you're not going to send them out for testing. If you do it based on their behavior, you could simply discipline because of the behavior they're exhibiting in the workplace is not acceptable. And I think sometimes that's easier than doing the drug testing. So make sure you review your policy, issue an updated one, and when you do the updated one, you don't have to hand out a whole new handbook. Just make sure you have the employees sign an acknowledgement form that they got the policy on such and such a date, and they understand it's their responsibility to read it and abide by it. You want to keep that acknowledgement in your in the personnel files. Okay, well, when you test for reasonable suspicion, what are you doing? First of all, don't rely on office gossip. If somebody comes into you and they say, "Hey, I saw Michelle eating these funny things in the bathroom a little while ago," or "I saw Susie's out in her car. It looks like she's smoking a joint out there," you want to observe it for yourself. Right? If if you observe the behavior, you may ask another manager to also observe, and what are they seeing? Document what you're observing. And there's a whole list if you Google this in terms of what kinds of behavior you might see. I mean, some of it could simply be glassy eyes. It could be somebody who is just not focused at all. It could be somebody who starts talking and they just go here and here and they're just rambling all over the place. It could be somebody starts coming in late every day, or they have frequent absences when they never used to be absent. And this isn't just for marijuana, it could be for alcohol, it could be for other illegal drugs. Sometimes it's for a prescription drug that affects them based on some illness they have. So based on your observations and you're going to document them, you need to meet with the employee and give them a chance to respond. Sometimes we found that the employee is truly on a new medication for some illness, and it's affecting them weird, but they think, okay, nobody will notice. In that case, you do have the right to ask for a copy of the prescription or get a doctor's note about it. But certainly, if anyone is coming into work and they're putting themselves or a patient or another employee in a safety situation, I certainly wouldn't want the medical assistant or the nurse practitioner or anyone that's possibly going to give me a shot or do something. I wouldn't want them under any influence. But give them a chance to respond and document all of that. That's something you want to keep on file. So some interesting times ahead, I think, uh, with the whole marijuana thing, but lock it down now with a good policy. All right. I don't think there was anything in this past year, year and a half, that caused HR people, office managers, more angst than the Delaware Paid Family Medical Leave Act. in terms of how to implement it. It got off to a very rocky start. There was a whole lot of information just being spewed out there that really didn't seem to have a lot of substance. There didn't seem to be any method of implementation. And for most people, your head was just spinning of, I don't know who it applies to. I don't know what I'm supposed to do. um, the state was doing some a number of webinars in order to get people up to speed on it. And as it got closer to implementation, I found out their webinars got better and they became more focused in terms of here's what you have to do. The de.gov/paid leave is a great website with all kinds of information. On that website, there is a phone number that you can call them. And I can't tell you over the last 6 months how often I have either called them or emailed them. And I have been very impressed with how quick they are to respond, how on point their answers are, and that's to email or to a phone call. So use it. And I wasn't in any time I called, I was never stuck in some phone queue that I had to wait a long period of time for. And I hit them with some pretty specific different questions like unions and things like that that weren't covered in the guidelines they have. They do have a very good on their website booklet guidance for what you have to do based on your size and things like that. So they pulled that one out at least to get us through. I won't say that getting registered to use the Labor First platform was easy, but everybody had to do it. All right, so let's. This is my one shot of everything you need to know about Delaware's paid leave. Right now, we are in the period of all we have to do is pay the contributions for 2025. There's no bucket of money in order to pay claims available yet. So this year is just funding that bucket. So in 2026, people can file a claim. The, there are some key numbers here. First of all, eligible employees. You only include somebody who is working 60% or more in Delaware. If you have a remote employee and they work in Pennsylvania or Maryland, most of the time or all of the time, you do not have to include them in the group and cover them for this leave. But side note, Maryland is in the process of putting in something similar. It was supposed to come into effect in July. Right now, it looks like they're trying to push that out till 2027. So eligible employees, 60% of the time in Delaware, they have to be employed at least 12 months with your company. They do not have to be consecutive months though, but at least 1,250 of their hours have to be during the previous consecutive 12 months. So all of those people are eligible depending on the size of your organization. And there's 4 different kinds of leaves that are covered under this act. One is parental leave. Parental leave says the employee is going to get up to 12 weeks in a 12-month period if they have a baby, if it's a birth, adoption, or fostering a child. It does not cover somebody who gets married, and the new spouse, maybe they have 5-year-old twins, and so it's like, hey, I'm a new parent now. It doesn't cover that situation. It's got to be a child that's new to your family. The second piece of it is medical leave, and medical leave is only for the employee's own serious illness, not for anyone else's. And they would have up to 6 weeks in a 24-month period to use medical leave for their own serious health problem. There's family caregiving leave. This is 6 weeks in a 24-month period to care for a child, a spouse, or a parent with a serious illness or injury. Notice it only covers child, spouse, and parent. It doesn't cover in-laws, it doesn't cover grandparents, it doesn't cover siblings, it doesn't cover aunts or uncles, just those 3 people. So you need to keep that in mind because that does differ from the Federal Family Medical Leave Act. The last piece of this is the qualified exigency leave, and this is for military people. And you would have up to 6 weeks in a 24-month period if somebody in your family is deployed overseas. There's an overseas military deployment. So this would not cover somebody who has gets they're in the National Guards and they get called up. Maybe they get called up to go to New Orleans because there's a major hurricane or something like that. So it's only overseas. All right. So with those four leaves, it depends on your size which ones you have to offer to your employees. If you have nine or less people, or it is less than 10, so nine or less employees that are eligible, you do not have to participate in any of this. You didn't have to register online. You don't have to do anything, except you need to make sure as you approach, if you're growing to 10 people, you've got to be tracking that. So once you hit 10, all of a sudden, you're now going to have to offer something. The companies with 10 to 24 employees, you have to offer the parental leave, just the parental leave. You can voluntarily provide the other leaves and pay for them, but you do not have to offer them. Now, the situation I heard a lot from some of our small employers were, well, wait a minute, all of the people in my organization, they're too old to have kids. They're never going to use parental leave. Can we exempt them? And the answer is no. You could have 23 people and they're all over 65 years old or 60 years old, and there's no shot they're going to have a kid. But, well, maybe they could, because if they got remarried or something, somebody younger, they might become a parent. But chances are pretty good they'll never use this leave, but you still have to participate in this. And the cost of the parental leave is 0.32%. So that's 0.0032 times somebody's Social Security wages. Once they hit the top of the Social Security wage um, limit, you don't have to pay this anymore. So it's 0.32%. You may split half of that with the employee and take it as a payroll deduction, and the company pays the other half. Or you can pay all of it, or you could pay 60% and charge the employee 0.6%, 0.6%. But you cannot take out more than half of the cost from the employee's paycheck. If you have 25 or more employees, then you're going to have to offer all four of those leaves. It's mandatory. You can't pick and choose. And the cost for all four of them is 0.8%. So 0.008 of the employee's Social Security wages. You can pass on 0.4% of that to the employees. The So it's really important if you are borderline of that 10 or the 24, 25 that you're keeping track, because your situation for your company could change. By the way, the maximum leave for all of these leaves together, if you fall in the group that has to provide all of them, it's a combined 12 weeks of leave per year. So if somebody takes 12 weeks for parental leave early in the year, they have nothing left during that calendar year, right? FMLA is being based off of my calendar year, or right now it is. All right, so keying in on those two important numbers, 10 for 10 employees and 25, they are going to mark the line between whether you gain coverage and now you have to start offering it, or you lose a type of coverage because you lost employees and you've now fallen below one of those lines. As your employee count rises, the group is going to gain additional coverage. So if you're in the up to 10 people, 10 to 24, and all of a sudden you go over into the 25, you now got to offer all four leaves, not just the parental leave. As your employee count falls, your group is going to lose coverage. And of course, it's going to gain that coverage a whole lot faster than it's going to lose coverage. Um, And the changes in coverage are not immediate, but some of them come up pretty fast. So you need to provide a notice to your employees when you're going to start deducting or change the deduction to their paycheck for this coverage. You have to give them 30 days notice. So after you hit 10 people, or you go from 24 into the 25 bracket, you got to give employees 30 days notice that they're going to be gaining some coverages. They're either going to be gaining parental leave or they're going to be gaining all of the different leaves. And therefore, you're probably going to be taking more money out of their paycheck. Um, you can stay on the coverage if you lose coverage because let's say you had 11 people and now you drop down to 9. You can stay on the coverage for 13 consecutive months. So you have to keep offering it, even though you now have less people for a year plus a 30-day notice period. For the companies that gained employees and now you have to add additional coverage, you only have 30 days after you hit that higher number to now cover the employees for the additional uh, leave pieces and start charging accordingly. So just numbers you've got to stay on top of now and track. I'm not sure. I don't think payroll companies are doing this for people. So it's just one more wonderful thing that gets added to your plate. Um, People will lose coverage 12 months, but you still have that 30 days to notify people. All right, so important dates. The first one that caused a huge amount of angst is behind us now. September to December of last year was when you had to register with Delaware Labor First platform if you had over 9 people. And you also had the option to opt out of the state's plan and choose private insurance. January 1 was the state plan contribution started when you had to start withholding if you were going with the state plan. If you went with private coverage, you did not have to start withholding contributions. That will be next year. April 30th, 2025, coming up, is going to be the first quarterly hour and wage report. It's going to be due, and you're going to have to pay your contributions. It's similar to paying your unemployment tax. I'm not sure how payroll companies are handling this. I'm sure each of them have their own pieces they're going to be doing. You do have to self-report your quarterly information on Delaware's Labor First platform, or your payroll company will do it for you. But just be clear who's going to do that. And my understanding now is even if you filed and you opted out, you got private coverage and you're not withholding anything right now, you still have to file a quarterly information report with Delaware Labor Force. And I couldn't find anything about that on the website, so I'm sure that will be coming up. All right. Good news, private plans. If you got private insurance, the insurance company is going to fully administer and pay all claims. You don't really have to do anything with that. However, if you are on the state's plan, you are going to now be responsible for administering claims from start to finish, and you're going to have to coordinate the claim payments. This is not good. It's one more extra thing I'm sure you didn't need added to your list. And this will start in January in 2026. So congratulations, you're about to become an insurance expert person here. All information relating to claims, they're going to have to be input into Delaware Labor First platform. There's no paper forms um, allowed. You will have to provide and collect documents related to an employee's claim. You're going to have to help the employee complete those forms. Then you're going to have to, once they're completed and you've got the supporting documentation you need from a healthcare person, you're going to have to submit them through the Labor First platform. And you've got 5 days to adjudicate whether that claim application is going to be permissible. You can look at all the facts, and you're the one who gets to decide whether, yep, it's a legitimate claim and the employee should be paid for it. So you determine what it's going to be. The state has been adamant they are not going to make that decision for you. You will need to communicate your determination via the portal again, and expect it will have some claims management tools for employers. Those are not available yet, but the state is looking into putting in those tools. You're going to have to calculate what's the employee's weekly benefit based on the situation and the coverages you offer. And then you get to determine how long those benefits are going to be paid to this employee, not the state, you. And if there's an appeal, the employee doesn't like the way this turned out because they thought they should have gotten more time or their claim was legitimate or whatever, you're going to have to participate in the appeals with the state. The good news is if you didn't opt out for private insurance, every year you get a chance to go out and get a quote for this private insurance. And I think there are 8 companies that have been approved by the state of Delaware to offer the private plans. And we found that the rates were very, very similar to the state of Delaware. And in some cases, they were a little bit less than the states. So October 2025 will be the first application window to opt in or look at decide you want to do a private plan, and you'll have to get quotes before that. Um, but you still are going to have to contribute to the state's plan for all of 2025. Now, what can the employees get for this? They are allowed to 80% of their pre-tax average weekly pay over the last 52 weeks from the date of their claim. So you're going to have to go back, and it's a look back period of 52 weeks. You can't just look at their W-2 from this past year in order to determine how much they're entitled to. The minimum benefit is going to be $100 a week. The maximum benefit is $900 a week. These will our plans will be working alongside short-term disability plans and some of the AFLAC plans. I talked to Fred Wilson several months ago about how is this going to affect, particularly the short-term disability plans, and in many cases they're going to run side by side. So that's going to complicate. I'm sorry.
Yeah. Did it work? It
Oh,
did.
can you might want to mute yourself, somebody, not sure who. But you're going to have to take into consideration if you're offering those other benefits, how it's going to fall in, because they're going to be happening at the same time. In no case should an employee be making more money than they did before they went out on leave. All right, still to come, and this is very complicated, but the feds recently came up with some guidance in terms of, is this a contribution? Is it a tax? Is it a premium? Is it pre-tax, like your health insurance premiums maybe, or is it after tax? And it's complicated. Your head really spins when you look at it. So that um, another fun thing that will be coming up. The guidance was issued this past January, but there's transitional relief for everybody for 2025 payments in terms of how it's handled tax-wise. You just take it as a business expense this year until they have more you have more of a chance for the accountants of the world to figure out exactly how it's going to be handled. Plus, there's also the piece of when the employee is collecting the benefit, is that taxable income to them that they have to report on their 1040, or is it not taxable income to them? So that's all coming out down the road. You want to make sure you create a Delaware paid family medical leave policy. Now, you don't need that right away, but you want to have something in place before January 2026. I will be putting out one of those at some point, but it's not really available at the moment in terms of uh, what you have to have in it, but it's going to be very similar to your FMLA policy. By the way, you want to make sure your FMLA policy gets tweaked to now include Delaware paid leave. They should be running simultaneously. It's not you get 12 weeks for the feds and 12 weeks for the state. Okay, enough of that. That's just, it was so complicated. And I'm really excited to see what's going to happen next month when we have to report. All right, let's look at some fun stuff. I don't know how many of you may be using artificial intelligence right now, AI. It's like Google on steroids. It gives you so much information. And let's look at some ways that it can help make your job easier. And there's some ways it can. You want to use the two that, the three that are the most prevalent are Copilot that's built into Microsoft 365. There's also ChatGPT and Gemini. Google has come out with Gemini. I use Microsoft Copilot and ChatGPT actually on a regular basis now for stuff that I just never imagined I would have available. You want to use it responsibly. There can be issues with data privacy, with fairness, and potential biases on information you get. Do not put in actual names of individuals. Don't put in social security numbers. Don't put in any name of your organization. You've got to be aware of its limitations, and you also have to keep in mind nothing is private that you put in there. So don't rely solely on it, because it will sound very, very convincing when you ask it a question and it comes back with a response. You're like, wow. However, it could be incomplete, it might be wrong, it could be inappropriate. So you always want to look at other sources also if you're trying to find data on it. Use your judgment and double check facts before making a decision or acting on it based just solely on the response you get. Uh, uh, if you've noticed, when you go out on Google now to do a search, pretty much everything that comes up, the first thing you now see is AI overview. And there's a lot more information than you used to get from Google, and that's all artificial intelligence. It's not always right, though. All right, so how can you use it? I like it for salary information. Typically today, when you want to put an ad out, I know with Indeed, you have to post a salary. They will not let you get past posting the job unless you put in a salary or a salary range. Like, oh, geez. And it was hard before to find out, well, what are other practices doing, or what's the going rate in my area? If you go out to ChatGPT and you ask, what are medical practices paying in Newark, Delaware for a medical assistant? There's a number of responses that come up. And these are the responses I got a couple of days ago. They'll give you an hourly range. Then it will give you the actual names of practices, and it will give the rates, and it will have in teeny little letters above the something in teeny print, it will have either Indeed or Glassdoor or ZipRecruiter or something. And you can click on that teeny little thing, and it will take you to that job posting or take you to the website with the medical assistance jobs. And there's more information available there.
Good morning. Good morning. How are you?
Hello.
My heart.
Can you please mute? Thank you. All right. Another thing you can do with it is if you are drafting an email, you have to write a memo, or you need to do an employee write-up, right? You can put into chat or one of these, please help me draft an employee write-up for the following situation. And then you just give it all the stuff. You just kind of like vomit on it. Here's all the things I want to include. It could be, you list the details. You ask AI to please draft this memo, write up, and put it in a neutral, friendly tone or a stern tone. You can ask them, all right, what follow-up items should you consider or include in this write-up? You can also ask them what discipline measures would be a good idea to happen based in this situation. You might ask them, what are some resources that you could give this employee based on the situation that could help them? So lots of good stuff in these things. You're not really looking at data. I will tell you, when I have a situation with an employee and they've just about got on my last nerve because they're constantly complaining about something or finding fault with something, and I just constantly the whiner. I think most of us have a whiner somewhere in our lives, or had one. And you can write it and you can just say, I have just about had it. This is the last time I'm going to tell you this. And you can spew out all that anger on AI. And then you can say, please put this in a neutral tone, or put this in a friendly tone, or a stern tone. It's wonderful. It is amazing what AI will do with your words and put that into a thing that you're like, wow, in a million years, I never could have written this. I also find when I'm trying to write something and I just don't really know where to start, I can throw out a bunch of, you know, pieces of it, and AI will put it into some coherent thing. It's amazing. Um, Use it to help you write interview questions. Please create some interview questions I can ask when doing an initial interview with the candidate for a medical assistance position. I'm not going to read these, but these were I think they spit out about 20 questions that they gave me. Some of you may be using some of them. Some of you may not have considered some of them. I just used ChatGPT for hiring a scheduling manager for a company, not for a medical practice, and it gave me some amazing questions. I never would have asked them on a phone screen, but I got some really good insight into the candidates on those. You can use it to help you write a new policy. I'm making myself obsolete essentially, so none of you have to call me anymore. Uh, it creates bullet points for a conversation that you have to have with a difficult employee or with a patient or even with one of your doctors. It ask for recommendations for training. Could you suggest some videos? Could you suggest some books on different subjects that you need help with? There are also a lot of other areas it can help you with. Once again, you want to be very careful in terms of the privacy thing. You can ask it about operational efficiency. I think I put in the chat, I said something about what can you, I'm a practice manager with a uh, medical practice, and what other things can you help me with? And it came back with this massive list of things: patient payment best practices, how to collect things, employee retention and engagement strategies, how to reduce patient wait times and optimizing front desk operations, strategies for online reputation. So lots and lots of great stuff out there. As long as you are aware that there could be, some things that aren't quite right in it. All right. Pregnant workers. There's four various acts that you really have to keep in mind, and they're all very similar when it comes to protecting pregnant workers. There's the four across the top of the slide. You'll have copies of this, so I don't have to get into them, other than the fact that the federal laws protect anyone if you've got 15 or more employees, but Delaware came along and put in a similar law that says if you got four or more people, you cannot discriminate based on somebody's pregnancy or childbirth or related medical issues they're having in terms of hiring, firing, paying them, job assignments, promotions, layoffs, training, benefits. You also have to provide accommodations that are reasonable for somebody who is pregnant. And that could be things like extra break times, a chair to sit, ability to sit down more often, or to, if their job is standing, is the way you could get them a stool so that they could be sitting, put their feet up, whatever medical condition they might have, and you would have an interactive dialogue with the employee about that. And the Pump Act, which was the private room, private area in terms of somebody who's had a baby and they can pump breast milk, that it can't be a bathroom. And also, they updated that rule. So it used to be just for hourly employees. It now also covers any exempt employees. So employees who don't pay overtime to now fall into this. All right, let's look at salary thresholds. I don't know if any of you this past summer got different notices from payroll companies and different resources you have. But in 2024, the Biden administration finalized this rule that was going to increase the salary threshold. So if somebody is an exempt employee, they fit all of the duties list that if they were making right now, if they make $35,568 a year or less, you still have to pay them overtime, even though they're a manager of something, they oversee two people, and they fit all of those rules. Well, the Biden administration kind of overstepped the Fair Labor Standards Act, and they put in these rules that said, come July 1st of last summer, we're upping that salary. So anybody who makes less than 43,888 is going to now you're going to have to pay them overtime. And in January, we're going to up it again, and it's going to go up to 58,000. Anybody below 58,656, you're going to be paying them overtime if they work more than 40 hours a week. They also put in a piece that said, in every 3 years, we're going to do an increase in these numbers. A lot of outcry about it because it happened pretty quick. They came out in April, and by July, you were supposed to put this in place. Well, November 15th came along, and a federal judge in Texas filed something, and they blocked both increases. So those increases did not happen. Of course, July was in there, and so a number of companies had probably given people raises or were paying overtime uh, just to stay in compliance. And now they didn't have to. Well, good luck about taking those raises back. I'm sure that didn't happen. Those lawsuits are still currently pending. So for now, we're back to the 2019 level. So I think this administration has a lot of other stuff on their plate right now, and I'm guessing this one's not on the top of the list at the moment. All right, so right now we just stay where we are with 35,568. And it doesn't matter, by the way, if you call somebody salaried, based on their job duties, um, you may have to pay them overtime. So that's a thing I see all the time is, well, just we give them the same salary every week or every month pay period. We don't have to pay overtime. That is not true. You need to look at actually what they're doing and if they fall into one of these classes. All right. You know how I told you AI isn't always correct? Well, when I was Googling the salary threshold exemption um, for this presentation, the first thing I got was an AI overview, and it says for 2025, the salary threshold for exempt, blah, 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 is 58,656. Now, if I didn't already know that that this had been blocked by a judge in Texas, I'd have been like, oh, shoot, I'm in trouble. But I knew it. So I thought, okay, well, that's wrong. And I kept reading. And so further down, it talked about the federal block. And it says, a federal court blocked this increase. As of now, the salary threshold for exempt remains at 43,888. Well, that was the number it was supposed to increase to in July. And that too was blocked. So, two things that if I had relied on them, probably some people would have gotten a nice salary increase. So you just got to be careful and check some extra resources. Affordable Care Act, the changes to the ACA annual filings. There is Affordable Care Act for any employer. If you offer a self-insured health plan, regardless of the size of your company, you you have to file the ACA filings. These are on a calendar year basis, and they are due. There's different dates after the year. Uh, March 31st is the final date to e-file everything. If you are an applicable large employer, you have 50 or more full-time employees during the prior calendar year. So right now, if in 2024 you had more than 50 people, then, and there's a special way to count it, you can go into all of the regs for ACA, that for 2025, you're going to have to be tracking who is eligible for health insurance, who you offered coverage to, did they take it, did they waive it, who is not eligible, who is in a waiting period. They have to wait 30 days or 60 days to get coverage. You have to track all of that stuff, and you're going to have to report that come 2026. Uh, Payroll companies, most of the payroll companies have the ability to track this. It's usually not cheap. They're going to charge you a bunch of money to do it. And they'll, do the tracking at the end of the year. You're going to have to do some work on that, but it's just one more thing added to your plate. And this is true whether you offer fully insured plan or self-insured plans. If you're over 50, you got to do this. So what changed this year? The good news is in this past year, you're not required to send out the individual forms anymore to the employees. Used to be you had to send everybody a form that showed if they have coverage, how much it costs them, and a bunch of other stuff. But now, and the employee had to file it with their 1040 return or had to have it available if it was ever questioned. You still have to prepare these, but you are not required to send them to employees. So you just have to send them a notice 30 days before, which would have been March 3rd, that says they're available. If you want it, you can request it and we'll send you a copy. The other new thing that happened this past year was used to be if you had less than 250 forms of these 1095 forms, you could just mail in paper to the Internal Revenue Service. Now, if you have 10 or more forms of the 1095 individual people, you have to e-file them. And that's caught a number of companies because there's a big gap between 250 people and 10. There are software programs we use yearly, yearli.com, that you put the information into them and it will do the electronic filing for you. But those are due next week. All right, political discussions in the workplace. Can be a hot topic. There's a whole lot of angst for the last few years around politics. And when people start talking about it in the workplace, it can make people uncomfortable. It can have an impact on your business. It can cause productivity to decrease because if you've got one person on one side and one person on another, and they just can't deal with each other, it can affect productivity in terms of they don't want to, have to go to that person for something that's part of their job. And interestingly, only 8% of companies share workplace guidelines around political discussions at work. So they're not even telling people what they can say or can't say, or just don't say anything kind of thing. You really should have a formal policy around political speech before things go nuclear before employees. And in the handouts is a sample policy that you can use to customize for your workplace about this. It's a great idea to have it. I don't think this animosity between the different sides is going to go away. It seems to escalate, and people are like, I'm in one camp or the other camp, and I don't want to deal with you if you're in the other camp. I heard one of our top people, uh, I said just before the elections, if anybody who doesn't vote for X is totally stupid and ignorant. And 4 or 5 people heard him say that in the office, and they were on the other camp, and so it was a real problem. So get ahead of this, get a policy out there that gives people a framework of what they can do and not do and how it's going to be handled. You can't ban all discussions, but you can encourage everyone to respect each other's beliefs and avoid this inflammatory topics. Refrain from sharing politically charged content on company channels, which, if you've got a company Facebook page or some kind of social media, that you refrain from it. If you know it's a social media that everybody in the company looks at, you could put that in. Good luck if it's, somebody's putting out their personal beliefs and involved in the discussion, and it has nothing, it doesn't have your practice's name on it in any way related to you. You really can't prohibit that, unfortunately, but you can prohibit engaging in the political discussions while on the job. You can prohibit in any kind of communication, emails you're sending out to people, uh, that sort of stuff, or displays of political signs, posters, or on clothing. You can ban that from the workplace. The message is you got to respect the workplace, avoid the conversations or actions that will create this discomfort or division. Respect others' views and beliefs, even though they're not yours, and maintain a neutral professional demeanor when interacting with patients. And I think this can be difficult because when I think about my dad years ago and his very outspoken as they get older, they just tend to get a lot more outspoken and think, hey, I'm 85 years old or I'm 87, I can say whatever I want to say. And, if they're sitting in your office as a patient and they're going off on one of your employees, it can be really difficult. But you need to encourage them to stay neutral and not get sucked into that discussion. Their top job is payroll, is patient care, and prohibit the political discussions. Treat the patients with respect. If there's a violation, you want the supervisors to remind the employee, if they hear it, that this is prohibited. And repeated violations or behavior that disrupts the office environment could result in disciplinary action up to termination. What should be in your policy? There should be a clause on enforcement. Um, there's a the sample policy will give you all of the pieces that should be in it. Make sure you have the employee sign an acknowledgement of that policy, and you keep a copy of that in their personnel file. Real quick, updated forms. Just make sure you have the right versions. The current version for the I-9 form, it says edition 080123, and it says expires 05/31/2027. So make sure you're using that one. There have been some changes to the forms. For remote employees that you never see, it was during COVID, we could hold up the documents to the camera on Zoom, and that was acceptable. It's no longer acceptable if you're trying to document a remote employee to make sure that they can legally work here. You have to use E-Verify to do that. Family Medical Leave Act. It seems like as soon as I get all those forms downloaded, they change again. The current forms, you can get them at dol.gov. The current forms all say expire 6/30/2026. They're except for the poster of an employee's rights under FMLA. The current version says revised 0423. So to make sure you have the current ones of those in your system. That's it. I'm sure I took up the whole, oh my God, right on the button, but hopefully we've got some time if anybody can stay that we can do some questions. Let me stop sharing. All right.
Thank you.
Any,
We do have two questions that popped up.
okay.
Um, the first question was, does the 12 weeks in a month period need to be continuous or broken up? 2 days this week and 3 days the next week.
Is this all based on the bringing people back to the, I see it now. Does 12 weeks and a 12-month period need to be continuous or broken up?
Linda, I think under
Yeah.
the MLA that working, they have to work 12 weeks.
Oh, they're allowed to take 12 weeks off in that 12-month period. If this is about the paid medical leave.
It's
Yes,
about the paid
about the
medical leave.
FMLA. Yeah.
I'm sorry, it's about FMLA
Yeah, she said it's regarding FMLA.
or the Delaware FMLA. You can take intermittent leave. So if somebody's going through, if I'm understanding this right, if they're going through cancer treatment, suppose, possibly they would have, a few days that they could work and they wouldn't have to take that solid block of time.
Oh,
But
I'm sorry, she clarified. She says it's DE parental leave.
Okay,
You want to
Delaware,
go ahead and unmute your go ahead and unmute your microphone, and
yes.
you can certainly ask Linda your question.
Yeah, my question is, if the employee wants to take, say, 6 weeks off under the Delaware parental leave, but then decides that she wants to take another 6 weeks later on for the same thing, can it be broken up, or does she, if she wants to work maybe a couple of days after the 6 weeks and then up to make up the 12 weeks, and she
Okay.
wants to work another 3 weeks, another week? Can it be broken up, or is it
Well,
be continuous 12 weeks?
I'm going to be honest, I don't know. And Delaware has not addressed this yet. My understanding is because once you apply for the leave and you start getting the benefit, the paid benefit, it's since whatever time you put into the system that they would be taking off. So it's not like federal FMLA where you can use intermittent leave as long as you use that 12 weeks up within the 12 months that after the child was born. Delaware hasn't, to my knowledge, fine-tuned that yet. I'm going to guess, particularly if you're administering this, that it's going to be in one chunk. Because if not, you'd pay a benefit this week and then you'd have to file again to get the benefit 2 weeks later. And I don't think Delaware's going to be set up to do that, or you're going to want to do that, right?
Okay, thank you for that. I appreciate it.
But I would say that is something that as we get closer to January, certainly we can ask Delaware that, calling the phone number that's on their website or emailing them directly. But I have a feeling they haven't quite got there yet.
Thank you.
All right.
Okay.
Anything?
Yes, we did have another question that came in about Social Security. What do you mean by 0.8% cost of Social Security?
Okay. Okay. Good question. If you are in the group that has to pay have to allow all of the leaves, the parental leave, the medical leave, the family caregiving leave, the cost is you're going to have to withhold, you're going to have to pay in April uh, all of your employees' wages, assuming they have not hit the Social Security maximum. Social Security maximum this year, I think, is, I want to say $178,000, and then you don't withhold Social Security anymore on those employees. But I'm not positive about that number. You'd have to check on it. But when you hit that, you don't have to pay tax, pay that premium or tax any longer for the year on that employee. So right now, early stages of the year, I'm sure probably nobody's hit that Social Security limit of the 170. Let's say it's 178,000. So you're just going to take the wages, everybody's wages times 0.008, and for a $50,000 position, I know it is. It's like $400 a year that you would have to pay on an employee that makes 50,000, and you could split that so the employee pays 200 and the company pays 200 over the year. Does that, I don't know if Jonah, if you're on, does that make sense?
Well, it's a bit complicated for me, but I can ask my payroll person or our CPA to elaborate more then.
Okay, but it depends on each person's salary.
Okay.
And there is a maximum that you would have to pay, just like when you pay Social Security. Once you hit a certain dollar amount, they don't take Social Security tax out on you anymore. And that would be the same as the paid leave.
Okay, thank you.
Okay, you're welcome. Anything else? I know I went through a huge amount of stuff. All right.
I think that was all the questions.
Okay.
If anybody does have any questions following this presentation, feel free to email me and I'll shoot those over to Linda.
That would be great. And I'll get back to you on those. Thank you all so much for all of this information I just dumped on you. So hopefully you're not overwhelmed. And let's hope for a year that it's not so bad this year. All right.
Thank you for
Okay.
the presentation.
Thank you.
Thank
Bye,
you,
everyone.
Linda.